All rise. We will there. The International Criminal Court is now in session. L'Alliance de la Cour pénale internationale est ouverte. Please be seated. We will just swap.
Good morning, parties and participants, and welcome to this status conference. I apologize for the compact size of this courtroom because there are other trials going on in the other courtroom, which is confirmation hearing of Ntaganda case. First of all, as usual, can counsel introduce themselves for the record of the court, starting with prosecution?
Certainly, Madam President. My name is Ben Gumpert, and with me today are Adeshola Adeboyejo, Manoj Sachdeva, Shamiso Mbizvo, Julian Elderfield, and Sam Lowry.
Thank you. Defense team, please.
I'm Stephen Kay of Queen's Counsel with Gillian Higgins, Disterio Oyatsi, Mr. Ben Joys, Kirsty O'Sutherland, as well as Mr. Kennedy Ogeta.
Thank you. Legal representative of victim.
Good morning, Madam President. Appearing for the victims today, I'm Fergal Gaynor. With me is Caroline Woolter of the OPCV, and to her right is Anushka Semi, our case manager.
Thank you very much. And today, representatives of the government of the Republic of Kenya are also joining us. And you are very welcome. And we thank you very much for attending this state conference. And the Chamber appreciates if you could also introduce yourselves for the record.
Madam President in the court, my name is Uhuru Muigai. I'm a senior counsel of the Kenya Bar and Attorney General of the Republic of Kenya since September 2011. I am also admitted to practice before this court independently. I am here today with my assistant, Mr. Dan Ochieng, Ms. Caroline Wamaitha, and Mr. Tom Odede. Thank you.
Thank you very much. And as usual, I'd like to remind everyone to speak slowly and to pause for several seconds in between speakers in order to ensure accurate transcription and transcription and interpretation. Today, we are scheduled to sit till 11 and take a 30 minutes break, and then continue from 11:30 to 1 p.m. We will only resume in the afternoon if that is absolutely necessary, and I hope not. This status conference was called on 6th February by Court Order 897. And the purpose of this status conference is to discuss matters relating to the prosecution's request for a finding of non-compliance pursuant to Article 87.7 of the Rome Statute. So far, we have received written filings on this matter from the prosecution filings 866 and 894, the registry, filing 877, and from the government of Kenya, filing 877 Annex 2. In the interest of efficiency, the Chamber would like to ask that submissions made in the written filings not be repeated here, as the Chamber has already taken careful note of them. However, we'd like to take the opportunity today to seek some further clarification on particular points. At the outset, we'd like to note that in principle, it would not normally the role of this chamber to interpret national laws. However, given that the questions before us relate to implementation of Roma Statute through national law and execution of requests made thereunder, as well as the fact that the government of Kenya has specifically invoked certain national legal provisions in its pleadings, and the Chamber would like to seek some further clarification on those matters relating to national law as well. As a preliminary matter, we note there is a disagreement regarding the interpretation of the word court in the context of making requests for assistance under Article 93(1) of the Roma Statute. I would like to start asking a question to the representative of Kenyan government. The first question is, our understanding of Kenyan government's position is that the court and the prosecution are distinct entities for this purpose, and that the obligation to comply with requests pursuant to Article 93(a) of the statute does not apply to requests made by the prosecution. Is that correct description of the interpretation of Kenyan government? And in your response, please, you may also, if you so wish, address the specific points regarding interpretation of the word court that are raised in the prosecution's most recent filing, which is filing 894. And now I would like to give the floor to the representative of Government of Kenya.
Madam President, first I want to say how much the government of the Republic of Kenya appreciates the opportunity to be before the court and to assist the court in arriving at a fair determination of the questions that have been placed before the court. In particular, we welcome the opportunity to clarify the interpretation of Kenyan law that has been placed before this court in the course of the hearing that has taken place. I wish to draw the court's attention to my filing dated yesterday, 12th February 2014, in which I have, to the best of my ability, tried to answer some of the issues that were raised by the court in the current order that has been served on us. But before I answer your question, Madam President, I would seek a clarification from the court, because when I look at the order dated 7th February 2014, in its material part, which is paragraph 10, it is stated there, Madam President, the Chamber considers that it would be assisted by receiving submissions from the Government of Kenya pursuant to Rule 1031 in relation to the prosecution's requests. At 11, the order states, however, the Chamber notes that the Kenya government has already extensively addressed the questions of its alleged non-cooperation in its observations. Therefore, in granting the Rule 103 request, the Chamber directs the Kenya government to confine its submissions only to the other two issues identified in Rule 12013 request. So I would like a clarification, Madam President, whether you and the court would like us to address all three issues identified at paragraph 7 of the order, or merely Roman 2 and Roman 3. Because what we have done in our response is respond to Roman 2 and Roman 3. And if the court would like us to respond more extensively as well to the general issue of cooperation, and therefore the distinction we have placed in our various opinions between the court being the trial chamber in one sense of the meaning, and the court being the trial chamber under the chambers and the registry and the OTP and the entire infrastructure of the court. If we are required also to make clarifications on this other point, we are happy to, but we need your guidance.
Thank you very much for clarification. The court would like to remind you that there are two distinct issues before this chamber. One is an issue relating to the prosecution's request for adjournment of trial date. And the order you referred to was relating to that issue. And the issue now before this status conference is about the another request from the prosecution about the non-compliance of the obligation under the Roma Statute. So for this state conference, the Chamber's intention is to concentrate on the issue of non-compliance. And your submission yesterday was requested in the context of the first issue, which is the adjournment of the trial start date. And of course, you are free to refer to your any submission of yours to the extent that it's related to the non-compliance issue, which is the issue before this status conference. And as for the your submission yesterday, we note that this submission is marked as confidential. And and you are, of course, free to refer to your submission yesterday, as long as this relates to the non-compliance issue. But if you want to refer to the submission yesterday, either you should ask for the reclassification of this document into public document, or if you want to mention any confidential information contained in this confidential document, we can always go into private session. So it's up to you how to refer to your submission yesterday.
First, I want to thank you, Madam President. I think that is where I should have started. The filing yesterday erroneously indicated that it was the desire of the government of Kenya to file it as a confidential document. We regret that error. Actually, it should have indicated that it was intended as a public filing. To the best of our appreciation of the law applicable in this court, there is no material contained in this document that is of a confidential nature. And if the court was pleased to permit a reclassification, we would be most obliged, and it would be classified as a public filing.
Thank you very much. So, court officer, can you reclassify this document? I think I don't have the number right now, but you know, into public document. Thank you.
Madam President, I would like to respond to your question about our characterization of our relationship with the court and its various organs by, if I may, giving a very, very short history, very brief history. The impression has been created in this court and elsewhere that the Kenya government has not at any time extended any cooperation either to this court as a judicial organ, meaning the chamber and its appellate component, or to the office of the prosecutor, or to the office of the registrar, or to the witness protection unit, or indeed to any person associated with the court. Madam Chair, Madam President, nothing could be further from the truth. You will find in the records of this court that the government of the Republic of Kenya, without any prompting, without being required to do so by any person whatsoever, voluntarily approached this court on the 8th of April 2013 and sought this court to permit that the government of the Republic of Kenya should place on record its various efforts to cooperate with the court. I don't know whether I should go to the history of that matter because it is very, very well set out in great detail, both in my filing, the response of the prosecution, and the order of the court that arose from that process.
Mr. Attorney General, I think, as I said, I don't think you need to go back to the contents of your written filings. The court has already taken note of this.
Very well. I appreciate that. In response to the very specific question you have placed to me, or rather addressed to me, which is the question whether the government of Kenya draws a distinction between the court as a judicial organ and the office of the prosecutor. The answer is in the affirmative. We do. And this issue, our opinion on this issue has been on record for the last 1 year. Indeed, it may very well be in excess of a year, because when I first wrote to Madam Fatou Bensouda, the prosecutor, on the 23rd of November 2012, a document that has and will be relied on by the prosecutor, I very clearly laid out this argument that the government of the Republic of Kenya took the view, a legal view, an issue of jurisprudence, that there were certain requests for cooperation that could be made by the prosecutor as an independent organ of the court, identified clearly in the Statute of Rome, and there were other requests of a judicial character that required a court order to be available for enforcement. If I have your permission, I would read from this letter very briefly.
Mr. Attorney General, I think we have your letter already in our case.
You do
file.
have my letter.
Yes.
So I want to affirm that it is indeed true that the government of the Republic of Kenya takes the view that the prosecutor is not the court. The prosecutor is not the court for purposes of certain aspects of cooperation of a judicial character that require to be supported by either an order of the court, a directive of the court, or merely a declaration of the existence of an obligation by the court. And we therefore took the view, for example, just to put that point to rest, that where the government of the Republic of Kenya was required to undertake a process in the Republic of Kenya, which was regulated in very clear and specific manner by existing Kenyan law, then there would be a necessity for the prosecutor to have approached the court with an instrument that is to be effected under Kenyan law. And allow me to say this. For example, Madam President, we have received from this court a warrant of the arrest of a Kenyan citizen against whom allegations of interference with witnesses have been made. Upon receipt of that warrant, we have submitted the warrant to the Kenyan judicial process. And as we speak today, Kenyan courts acting in accordance with the International Crimes Act, which is the law in Kenya, seeking to effect the Rome Statute, are already processing the warrants in that manner. It is our submission, therefore, that where we have been of the view that we could cooperate with the prosecutor without requiring a court order, we have done so. Let me give you an example, Madam President. The prosecutor admits that since 2009, the government of the Republic of Kenya entered an MOU with the court that facilitated the transfer of staff of the court to Kenya. These staff members remain in the Republic of Kenya under the protection of the Sovereign Republic of Kenya. That is a cooperation for which we did not need a court order. The previous prosecutor of this court, Mr. Ocampo, came to Kenya no less than 3 times, was escorted throughout the Republic of Kenya to meet whoever he wanted to meet in Kenya, whether in private or in public. That's a cooperation for which we did not need a court order. In my own tenure as Attorney General, Madam President, I have facilitated the visit to Kenya of Madam Fatou Bensouda. In fact, in circumstances in which we met at a conference in Berlin, and she said to me, I would like to come to Kenya. I said, give me your diary, tell me the day you want to come. I did not ask her for a court order. In Kenya today, as we speak, there are several investigations teams throughout the Republic of Kenya under the guidance of the prosecutor and the investigation office, being facilitated daily by the Kenya government to visit any place that they would wish. We have never asked for a court order. We drew the line and shall continue to draw the line unless there is an order to the contrary. When we were requested by the prosecutor, as of right, she asserted it as of right. She asserted the power of the court as a power available to her personally, and we disagreed. Madam President, when 2 lawyers disagree on how the law should be interpreted, it is not an act of non-cooperation. It is not an act of non-cooperation. It is issues are joined, and we invited Madam Prosecutor in the letter that you have said, Madam President, that you have seen. Over 1 year and 3 months ago, I told Madam Prosecutor, this is my understanding of the law, and I welcome the opportunity for you to go before the court so that the court may guide both of us. 1 year, 3 months later, the prosecutor has never come to this court on that question. The prosecutor now seeks to come to this court for an interpretation on that issue through the back door, through an application by A, where they seek to have a continuance on this matter indefinitely, and where the defense seeks to have the matter terminated. At that point, the prosecutor has remembered the long outstanding jurisprudential contestation, not lack of cooperation, a jurisprudential contestation where there is one interpretation of the law by them and one by us. And therefore, I summarize my submission on this point by saying, if the Kenya government was not intent on cooperating, this exchange of communication, voluminous citations of law by me, and I must, in fairness to the prosecutor, say by the prosecutor, quoting learned authors, quoting the preparatory text of the treaty. And therefore, I suggest, with tremendous respect to the court, that it is indeed our position that there is a distinction between the prosecutor as such and the court as a judicial organ as such, and that is borne out by the treaty and the rules. And that Kenya has not taken that position flippantly, frivolously, or to obstruct justice, but it is to ensure that the Rome Statute, the Constitution of Kenya, and the International Crimes Act are enforced in a harmonious manner. Thank you.
Thank you very much. Judge Fremr has a question.
Thank you for the floor. Mr. Attorney General, you said that the interpretation of different lawyers could be, one provision of by different lawyers could be different. That is why I would like to know your interpretation, and I'm sure that you know perfectly Article 34 of the statute, but maybe for the need of public I will quote it. Article 34, organs of the court. The court shall be composed of the following organs: A, the presidency; B, an appeals division, a trial division, and pre-trial division; C, the office of the prosecutor; D, the registry. So at least this article doesn't make any distinction among those organs. So may I know your interpretation of Article 34?
Yes, I would be happy to answer that. And I think it goes to the point that I was endeavoring to make earlier, which is this. This treaty, and indeed many statutes of state parties seeking to develop domestic legislation to enforce the treaty, speak of the court in two senses. When Article 34 speaks of the court in its corporate entity, this is the International Criminal Court. It is one entity with one seal. It is a body corporate. And within it, it contains the four divisions that are set out there. But you will note, sir, if you look at Article 38, for example, Article 38 talks about the presidency of the court. And Article 42 talks about the office of the prosecutor. Article 43, the registry. Now, let me give you an example of Article 48, privileges and immunities. When it says there that the privileges and immunities the court shall enjoy in the territory of each state party, such privileges and immunities as are necessary for the fulfillment of its purposes. That is the court in its corporate sense. But when we go to the question of, for example, the powers and functions of the court, for example, let's look at Article 62. Article 62 talks about the place of trial. Unless otherwise decided, the place of trial shall be the seat of the court. The seat of the court in this sense is the seat of the judicial organ. It is the seat of the judicial organ. It does not, in our very humble view, have the same meaning as you have identified in the corporate definition of the court. And when we talk in Article 62, say, of the powers of the trial chamber, now the trial chamber is a much more specific body, so that, again, the inference to be drawn there is that there is a recognition that the court functions as a corporate body for certain purposes, and the court functions as individual autonomous institutions for other purposes. And if I may say this with your kind permission, this form of structure that we have in this court, of which Kenya is a proud member, is a very unique structure in criminal jurisprudence. It is a very unique structure where you have the judicial chamber and the investigator and the prosecutor housed in one institution. Because in most jurisdictions, the professional distance between the judicial organ, that is the court, and the prosecutor, who is in an adversarial relationship with the defense, is a very serious matter. So in this, as we read the Rome Statute, I want to suggest we must remember that international best practices are where the judicial chamber and the prosecutions are completely at arm's length. Completely. I would say 3 arm's length. Because any other perception that the judicial chamber and the prosecutor are one organ would seriously do violence to our sense of justice and fair play. Therefore, we resubmit this. The prosecutor is not the court. The prosecutor is an organ of the court for functionality only. For functionality only. But the prosecutor cannot take the garments of the court and parade. The prosecution cannot parade itself in the garments of the court, demanding and invoking powers that inhere in the court itself as a judicial body. Because to do that would to create a playing field that can never possibly produce justice. That is my submission.
Thank you, Mr. Attorney General.
Another question I would like to pose to the government of Kenya. In the written submission of government of Kenya, you referred to the Kenyan International Crimes Act, the legislation which was passed in Kenya to domesticate the Roma Statute. And could you please confirm whether that is the relevant national legislation through which the prosecution request could be processed? And if so, we note that Article 2 of the International Crimes Act contains a definition of ICC which specifically includes any of the organs of the court referred to in the Roma Statute. And the term ICC is then subsequently used in the cooperation articles in this act. Could you clarify if that definition of International Crimes Act consistent with the interpretation of Article 93(1) of the Roma Statute, which you have just explained?
Yes, Madam President, I am happy to confirm that the International Crimes Act of the Republic of Kenya is the statute that we have used to domesticate the Rome Statute. And it confirms in its main title that this is an act of Parliament to make provision for the punishment of certain international crimes, namely genocide, crimes against humanity, and war crimes, and to enable Kenya to cooperate with the International Criminal Court established by the Rome Statute in the performance of its functions. Let me come, Madam President, to your question about Article 2. It is indeed true that Article 2 defines the ICC as the International Criminal Court established by the Rome Statute, excuse me, and includes any of the organs of the court that are referred to in that statute. We find absolutely no contradiction whatsoever. Article 2 is making the same recognition as the Rome Statute does, that the court exists in the first instance as a corporate body. And secondly, it exists in its distinct, individual, independent, but interdependent parts. And that's why, and I'm not a draftsman, Madam President, and I have great respect for draftsmen, and I think that the comma there is very material. The comma is very material. It says, the ICC means the International Criminal Court established by the Rome Statute, comma, and includes any of the organs of the court that are referred to in the Rome Statute. When you retire to deliberate on this matter, Madam President and the court, and this statute becomes available for you to peruse, it will become clear that, like the Rome Statute itself, it makes many, many distinctions between the court as a judicial organ, the prosecutor, the registry, and other organs. And let me give you just one example. Who is required to cooperate with the court under Kenyan law? There are two ministers, in that sense of that word. There are two persons who are required to cooperate, and that is part of our submissions which we filed yesterday. One is the Attorney General, and the other one is the Minister of the Interior. And almost without exception, the facilitation by the Minister of the Interior, which is considered by the prosecution in the hundreds of letters that they have written over the last 5 years, that Kenya, over 5 years now, that Kenya has been a situation country, is that communication with the Minister of the Interior requiring the cooperation of that ministry is almost exclusively in respect of non-judicial processes. And the cooperation of the Attorney General in almost 9 out of 10 is in regard to judicial or quasi-judicial processes. And therefore, I want to answer your question by confirming that in our own understanding of our own law, we enacted Article 2, Section 2.1 of the International Crimes Act 2008 to be read in the same way as we are able to read Article 40, sorry, not Article 40. I have misplaced, yeah, Article 34. I'm calling it Article 43. And the two are consistent, and there is no controversy whatsoever. And maybe if I still have 1 minute, can demonstrate that again by going back to a question that I have already addressed relating to the warrants that we received from this court. And again, you can see the multiple usage of the word court. Because this court was approached by the prosecution to issue a warrant. The court there means the judicial organ. The judicial organ, in its absolute discretion, made a judicial order. But the transmission of the judicial order to the government of the Republic of Kenya is not made by the court as a judicial organ. It is made by the registry as an organ of the bigger corporate court. And therefore, the meaning continues to be consistent. The meaning that the court as a judicial organ and the court as a corporate body are consistent is, in our very humble view, very clear. And therefore, our statute is clearly consistent with the treaty, which was our intention. Only before I sit down to mention that whenever it is said that Kenya has failed to cooperate with the court, the very existence of Kenyan law effecting the Rome Treaty is the primary evidence of the enthusiasm with which Kenya has always embraced the court since it became a party to the court. And I have looked at how many state parties actually have domestic legislation, and Kenya is in a very unique position in that view. And I also wish to add this. I have also looked at the history of this court, and unless I have missed something, I was unable to find in the history of this court, in excess of 10 years, an occasion when the Attorney General of the Republic in question, the situation country, has come to this court in person, not by retaining counsel, in person, to say, this is what we have done, this is what we are doing, and this is why we are doing it. That, to us, is the ultimate example of cooperation, the ultimate insignia of the respect that the Republic of Kenya holds this court.
Thank you very much. Thank you very much. We would like to move on to other more specific points. Unless any of the parties and participants wish to specifically address this question of interpretation of the word court beyond the submissions they have previously made on the point.
Your Honor,
Defense.
Your Honor, I remember being on my feet on the previous occasion last week and specifying within Article 93 that there was the court or the prosecutor, and I couldn't remember the particular provision. During the attorney's submissions to you this morning, I noticed it's Article 93, sub-Article 5, which I've been able to note, which is an Article 6, Article 93, sub-Article 6, which is consistent with the attorney's submissions, I believe, this morning.
Thank you very much. Prosecution?
On that precise matter, can I invite the court's attention to the very article and sub-article which Mr. Kay has referred? Article 93, sub-article 6. If a request for assistance is denied, I pause there because, in fact, this request for assistance wasn't denied until very recently. The history of the correspondence shows that the Kenyan government was consistently saying, yes, yes, we're getting round to it, until quite recently. But it is now, I accept, denied. Well, what should follow? We read on. the requested state party shall promptly inform the court or the prosecutor of the reasons for such denial. Well, this request, the request about which we are complaining, was made 22 months ago. There has not been compliance in any shape or form with that sub-article. The requests, I beg your pardon, the reasons now advanced have come very, very late in the day. There's one other remark which I seek to make relating to something which the attorney said earlier, and it is in relation to a document to which he referred. Now, I'm aware that Your Honours will be familiar with the documents, but it is one small portion to which I would refer you, because it casts a blinding light upon the merits of the position of the Government of Kenya. May I refer Your Honours to...
Mr. Gumpel,
Yes.
it is the intention of the chamber that we will discuss the issues of consultation and timing of the request at later stage.
Your Honour,
So
I was... Yes.
if you can confine your point to the issue of definition of the court and prosecution, I would be most grateful.
Your Honour, the points I make only arise from submissions which other parties said were relevant to your question of the definition of the court. So I make them in response to matters which have been said to be relevant to that. But in fact, this one point that I'm about to make, or one matter I'm about to draw to Your Honour's attention, which will take no more than a minute to do, is precisely on the question of whether or not within the word the court is included the organ of the court, the prosecutor. And it is a demonstration of the position which the government of Kenya itself occupied. It's paragraph number, it's at tab 16, and it's paragraph 16. Do Your Honours have it? Tab number 16 in the folder which I have produced for Your Honours. That is the Government of Kenya's filing of the 8th of April of 2013, filing number 713. That's a 20-page document. Do Your Honours have it? Yes? And paragraph 16 is on page 9. And this is what the government of Kenya submitted to the court was the law on the 8th of April of last year. Part 9 of the Rome Statute establishes a comprehensive framework for cooperation between the ICC and states parties. Article 93.1 details numerous specific types of assistance that the prosecutor and court may request from states parties, and which states parties must comply with in accordance with Part 9 of the statute. There, a clear acknowledgement, because I submit the argument they now advanced hadn't at that time occurred to them, that the powers set out in Article 93, which are, after all, the principal investigative powers which the prosecutor has, are indeed available to the prosecutor. Indeed, any submission to the contrary might be thought to be difficult to sustain. If the prosecutor can't investigate by asking for assistance under 93.1, what can it do? So those are the only submissions I make in respect of what has been said thus far.
May I,
Thank you
Madam
very
President?
much. Mr. Attorney General.
may I, with your permission, address that matter, lest it be understood that we agree with the submission. That submission is totally, factually inaccurate. The letter to Madam Bensouda that the prosecution has made reference to, which is dated the 23rd of November 2012, that cannot be described as a recent declaration by the Kenya government of its view. Indeed, in that letter, if I may read because this is important, this is what I said to her, the learned prosecutor. You will recall in our discussion during our recent meeting held on the 17th of November 2012, in which I informed you that the requests made to the Republic of Kenya must conform to the laws of the Republic. You will also recall that I reiterated that Kenya will continue to cooperate with the ICC within the context of its international obligations as provided for in the Rome Statute and the Kenyan laws. And it was important to note that Kenya has agreed to allow the ICC judicial process to proceed to its conclusion. And I said further, we draw your attention to the issues raised in our letter of 7th November. We draw your attention to the distinction. And when I finalized on the following page, I said, our reading of this part of the statute, the Republic contends that the request has to be from the court, which is distinct from the prosecutor, and that a court order has to be in place before this request is in force. In our view, a judicial process is necessary in order to avail third parties a chance to present their cases. It would be totally inaccurate to suggest that we made up our mind on what the law is a year later. We knew what the law is a year earlier, and we stated it. And I want to finally draw your attention to the document that the learned prosecutor has read. And I'm constrained to observe that he has read it selectively. He has read the preambular part of the document in which we were beginning to introduce the idea of the distinction between the court as a judicial organ and the prosecutor as an officer and an organ of the court. Because if you proceed with the paragraphs that he did not read, which I will not read, paragraphs 18, 19, 20, 21, 22, 23, we made the same argument. And we said, there is a distinction. In paragraph 23, we invited the prosecutor to come to this court, and seek an interpretation. That was 1 year ago. It would not lie in the prosecutor's mouth now to suggest that we have only recently taken this position, or we have only recently become clear what the law is. Finally, I think that I am obliged to Mr. K for bringing the attention of the court to Article 93.6, which in my very humble view should bring this matter to a very clear end. It says, Article 93.6, when it is dealing with forms of cooperation, if a request for assistance is denied, the requested state shall promptly inform the court or the prosecutor. Do we need any other evidence that the prosecutor is not the court? This section actually recognizes that a state that does not wish to deal with the prosecutor, not another state other than Kenya, Kenya is quite happy to deal with the prosecutor, can come directly to the court itself and say, the prosecutor was asking us for the following assistance, and we have told her that we can't give her. What did the Kenya government do? It said, we hold the prosecutor in the highest possible professional regard. As one professional to the other, I did not ignore her communication. I wrote to her and said, I am unable to facilitate this sort of cooperation because of the following legal reasons. It cannot now lie on the lips of the prosecutor to allege that we denied assistance and did nothing. No. We informed the prosecutor that of the following of your requests have been facilitated. You wanted a court file from a place called this and that place? Have it. You wanted motor vehicle records of the owners of this vehicle? Have it. You wanted this and the other and the other and the other? Have it. But of this and this and the other, please go and get a court order because that is the requirement of the law. Thank you.
Madam President.
Thank you very much. Mr. Gaynor, on this specific point?
Yes, on this specific point, Madam President, you referred to Article 2 of the International Crimes Act of 2008, which sets out clearly that the term ICC includes any of the organs of the court that are referred to in the statute. Now, when the Attorney General receives a request for assistance pursuant to paragraph 1I of Article 93 of the statute, he is bound by Section 104 of the International Crimes Act that expressly deals with requests coming from the ICC under that specific sub-article of Article 93 of the Rome Statute. Now, in the opening words of Section 104, the words are, where the ICC makes a request under paragraph 1I of Article 93 of the Rome Statute for the provision of records and documents, including official records and documents, the Attorney General shall give authority for the request to proceed if he is satisfied of two things. Now, my point at this stage, I'll return to this article later during my submissions, is that it's absolutely clear that if the request comes from the ICC, which is defined in Section 2 to include the organs of the court, the Attorney General must act. Now, if the Attorney General really, truly believed that the term ICC in Section 104 did not include the prosecutor, he was under an obligation immediately to come before the court under Article 93(3) of the statute, Article 99(4)(b) of the statute, and Article 97 of the statute. The obligation lies squarely on the state party to consult with the court. It does not lie on the prosecutor to litigate the matter. Thank you, Madam President.
Thank you very much. And I think it's a very good cue to go to the second, another issue, which is national barriers to execution of the request. And as I said, as for the issue of consultation and timing, who said what when, we will come back later, and parties and participants, including the government of Kenya, will have ample time to discuss this issue. But before going into consultation and timing issue, the chamber has several questions which it would like to ask government of Kenya about the national barriers to the execution of the prosecution request. And after that, of course, parties and participants will be given an opportunity to make submissions. Mr. Attorney General, in your written submission, you highlighted for the Chamber certain provisions of domestic law which your government submits create an obstacle to the execution of the prosecution's request. These obstacles include a right to privacy enshrined in the Kenyan Constitution, as well as certain provisions of national legislation providing for the non-disclosure of an individual's financial information in the absence of consent. The first very factual question. In respect of the information for which it is submitted that consent is required, has the government of Kenya sought the consent of the relevant individuals, specifically in this case of Mr. Kenyatta? And if you prefer to answer this question not in open session, we can go into private session, if you prefer.
I thank you, Madam President. I'll start with your last question. Has the government of the Republic of Kenya sought the consent of any of the accused persons before this court to release any documents that it may have? The answer is simply no. No, for very good reason. And that is the reason that has brought me to this court to explain. And it is fundamental to the confusion that has pervaded the submissions that were made in the absence of the Kenya government. The Republic of Kenya is a sovereign, autonomous, independent state. The governments that run the state of the Republic of Kenya are different. And every 5 years, voters go to an election to make a determination whether they will elect one person as opposed to the other. Madam President, since Kenya became a situation country, we have interacted with the court as the sovereign state of the Republic of Kenya. You yourself have said in the ruling to my amicus application that the government of Kenya is not a party to proceedings. And therefore, my own understanding of the law was that as the chief law officer of the Republic of Kenya, it was my duty to keep a clear, independent distance from the prosecution and from the defense, and to have a direct engagement with the court. I did not feel that it was in my place to contact the defense and to suggest to the defense how the defense should conduct its case, including facilitating or not facilitating these documents. Indeed, the further answer to your question, Madam President, is this. It is the duty of the prosecutor, in my understanding of best international practices in criminal jurisprudence, to seek from the defense a concurrence at the disclosure stage of the case. Let me, and this is not a lamentation, it is a statement of fact. One of the difficulties that the Republic of Kenya has had in this case, and why I filed my first amicus application, is because submissions were made in this case by all manner of parties regarding matters that were totally outside our knowledge. We, as you know, Madam Chair, have no access to the thousands upon thousands of confidential documents filed in this court. The Republic of Kenya does not know the list of witnesses. It doesn't know who they are. It doesn't know where they are. It doesn't know their identity. It doesn't know who has agreed to testify, then refused to testify, and it has no way of knowing. But that has not stopped the prosecution, and unfortunately sometimes other parties in the court, to make allegations about the government of Kenya relating to issues that the government of Kenya has no way of finding out. Let me give you an example. Both the former prosecutor and the current prosecutor have carried out a long public lamentation about the alleged obstruction by the government of Kenya, which they claim is manifested in the intimidation of witnesses. On more than a dozen occasions, Madam President, I have said to them, who are your witnesses if you want me and the Republic of Kenya to protect them? The answer, Your Honors, may shock you. The answer has been, we cannot tell you the names of the witnesses because they are not safe with you. So I am guilty of not protecting witnesses whose identity I don't know, whose identity I will not be given.
Mr. Attorney General,
Yes.
I'm so sorry to interrupt, but we have many more questions to ask, and the time is rather limited. So I plead you not go into details about the protection of witness issue, for example. Thank you.
I stand corrected, and I will go to your other specific point. And my answer is as follows. There is another misapprehension of the law by the prosecutor, which runs very deep in the proceedings before this court. And it is this, that if the prosecutor wishes for anything whatsoever to be done within the Republic of Kenya relating to this case, in whatever manner, that which the prosecutor wishes will be done irrespective, A, of Kenya's own understanding of its obligations under the Rome Statute. Our submission is that that is not true. The government of the Republic of Kenya does not take legal advice from the prosecution as regards what its obligations are under the treaty. The government of the Republic of Kenya takes legal advice from its law officers. That's point number one. Point number two, the prosecutor seems to be under a misapprehension that any request by them must be complied with irrespective of what Kenyan law may say, including and fundamental being the Constitution of the Republic of Kenya. There can be no such legal proposition that can be made in an international tribunal of this stature. The Rome Statute itself recognizes that the process of the facilitation of cooperation is subject to national law. The word national law is repeated a dozen times. And our submission, therefore, is this. What the Constitution of the Republic of Kenya says as regards the protection of the citizens of the Republic of Kenya regarding the disclosure of their private confidential documentation is a matter determined by domestic law. And that is beyond contestation.
Mr. Attorney General,
Yes.
my question was a rather simple one, because you said in your written submission that you need a consent of the accused in order to disclose certain information. I just asked whether you actually asked the consent from Mr. Kenyatta. And I correct in understanding your answer to be that you didn't you didn't seek the consent of Mr. Kenyatta because you are prohibited by Kenyan law to seek the consent, or you are not obligated by Kenyan law to seek the consent?
Said, Madam President, it is neither my duty under the Rome Statute nor my duty under Kenyan law to seek such consent. I have said that it is in an adversarial system such as is before this court. It is a matter between the prosecutor and the defense whether they will consent to the production of any. As I sit here now, and I'm afraid again it sounds like a lamentation, I don't know what the defense and the prosecution have exchanged by consent. I don't know what they admitted to or did not. What I have said to you, honorable judges, is this. If the Republic of Kenya were to descend into the arena of this conflict and were begin to make demands of the accused person, our position as an independent state party, not party to the proceedings before the court, would be irredeemably and irreversibly compromised. And therefore, my answer is the duty is a duty of the prosecutor, not my duty. But let me finish by saying that yes, it is true, I would not call this national barriers or national obstacles. I would say it is important to understand that cooperation with the International Criminal Court is subject to Kenya's own domestic law. And Kenya's own domestic law, because this is another misrepresentation I need to correct, does not say that we cannot give bank or financial statements. On the contrary, it says we can, subject to. Subject to. And that subject to is either the consent to be obtained in that manner or the obtainance of a court order, where the court itself is satisfied in very specific terms that this information, otherwise protected by the Constitution, the Central Bank Act, the Banking Act, and other legislation, ought to be disclosed for an overriding public interest that the court would define. Thank you.
Judge Fremr.
Thank you for the floor. Mr. Attorney General, now please forget about this case before the ICC. I would like to just ask you about practice within the Kenya criminal proceedings. If you or your investigators or prosecutors have a domestic case when accused is alleged for very serious crime, and according the intent of investigators or prosecutors, there is a clue that very important evidence could be found within his financial records. I can imagine that you can very rarely get consent of the accused. So how do you mostly proceed in your domestic practice in such kind of cases?
Under our domestic law, whenever we investigate serious crimes, say such as, say, terrorism, for example, and we want to access bank records, telephone records, or such other communication that is otherwise ordinarily protected by law, we obtain a court order. And I think that this is a very, very important part of this. I have reason to believe, and again, this is a difficulty I have in this case. I know for a fact that Mr. K and his defense team, because I read in the papers, I was not party to the case. I read in the papers that Mr. K and Mr. Kenyatta's defense team came to Kenya, went to the High Court of Kenya, filed proceedings that I didn't see because I didn't need to see them, and they said in those proceedings, to the best of what I was able to discern, could the High Court of Kenya allow them access to certain phone records? That's what I read. And I read later that an order had been made by the High Court of Kenya, which at one level involved a form of negotiation between the parties. And the holders of the phone records appear to have said, you know, the legal advice we have received is this, and the applicants did whatever they said, and some modality was found. That is the normal practice in Kenya. It is impossible that a prosecutor may walk to a bank and say, give me the banking records of Mr. Y, because not only would they have a constitutional violation suit against them, but they would also have a civil suit, which I don't think many banks would do. So even if we receive this order, we would send it to the central bank. The central bank would send it to the bank. The bank would write back and say, we can't comply with this order. It violates the Banking Act in this form and that form and that form. Do you have a court order? Now, then we have a stalemate because we don't have a court order. And it is the court in Kenya will not hear an argument that says, there is a prosecutor in America who has said he wants access to the record. Because a prosecutor is a lawyer like any other, only a lawyer acting on the public side of the dispute. Thank you.
Thank you, Mr. Attorney General.
Thank you very much. Well, I see now we have only 2 minutes to 11. We will adjourn right now, take 30 minutes break, and come back to this courtroom at 11. The hearing is adjourned.
All rise. We will lever.